Have you taken consent of the other side? Hmm? Okay. Your name, Mr. M. Mandal, and the counsel for the respondent has submitted that you, you want to do it at 2 o'clock. Okay. Okay. 11, just you'll have to wait for some time because these are old matters. There are 200 such old matters which are. No, it's okay. We'll consider your prayer, but let the matter be called. 12. No, in 12, something was required to be produced. Huh. In DV1, there was some order to produce something. So we'll have to see that is complied with. We'll consider your prayer, but there's some order, I believe, requiring something to be produced, or let us pass an order. Item 4. Okay. When do you want? Okay. When do you want? Okay. Both sides are represented on the prayer made by Learned Counsel for the petitioner. List on. Give a date after 2 weeks. Date. Yes. No, you see, we are not deterred by the volume. You want to take an adjournment is another thing. But so far as we are concerned, we are ready with the matter. Adjournment. Okay. Okay. Both sides are represented on the joint prayer made by Learned Counsel for the appellant and the respondents. Number 6. You have taken consent from others. There are other respondents. 5. No, but still not informed. We can adjourn the matter. So, matter stands adjourned today. Both sides pray that the matter be listed on a fixed date. Next matter. Accordingly, list the matter on 6/11/2025. 7th is a Friday. 6th. Okay. 11/11/2025. Accordingly, the matter will not be adjourned on the said date. Item? Yes. You can complete your part, we'll take it up. The other part will be taken up tomorrow or day after tomorrow. If you want, there is an urgency, we'll start hearing the matter. It's a case of nurses having diploma and degree. You can start arguing. No, then don't figure out on one or the other. He will give an adjournment, you will give a consent, and then you say they will give a fixed date. You're ready to hear the matter. No. On the both sides are represented on the prayer made by Mr. ARTL and counsel for the petitioner. In WPC 6306 of 2024, the matter stands adjourned today. Okay. 6306. Okay, accordingly, both matters stand adjourned today. List on 11/11/2025. On which date no prayer for adjournment shall be considered. Yes. Which matter? Item 8 and 10. Item 8 and 10. Huh? In item 8, you see, Miss, your name? S. I couldn't get it. Sheikh, Learned Counsel prays for an adjournment. The ground that the Learned Counsel holding the brief is hospitalized. Matter stands adjourned today. List after how many days? After 2 weeks. And in item 10, 11. Item 10, I think. 8 and 10. In item 10, you have taken consent of the other side. This is a state's matter. Yes. Okay. Both sides are represented on the prayer made by so and so for the private respondent. The matter stands adjourned today. Same ground. Huh? List after 2 weeks. Okay.
Item 1 for admission, WPC 5175/19.
In this case, Your Lordship, the brother of the petitioner has already been declared Indian, Your Lordship. And Lordship has already gone through the record, Your Lordship, which has been called for, Your Lordship.
Well, yes, we have seen here that madam. The only, my lord, probably in this case, my lord, the brother was declared foreigner, no, Indian, and the sister is coming on petition about court. last occasion, so we have examined the records, my lord, both the records are there, my lord. And it is seen, my lord, your lordship has also seen, my lord, the documents were exhibited in brother's case. Same documents, some of the same documents were exhibited in the sister's case also. On the same day. But though it was exhibited in different days, but it was signed on the same day, my lord. So that's why your lordship was supposed to look the record. And secondly, my lord, one thing your lordship will find. My lord, in this case, my submission is, my lord, your lordship has gone through the records already, my lord. I have also gone through. My lord, yes, there is a mention in the WS, my lord, he has a brother, she has a brother. My lord, but there is no mentioning, my lord, that any case is pending against the brother, my lord.
But you can't do anything about it. Your
Yes, yes.
member was negligent.
Yes.
He
No, my-
knew about it and then
No,
you don't
my
do
lord, my
anything.
submission is, my lord, when it is the case of the petitioner, it is on the first date, my lord, it is not possible on the part of the either on the part of the state authority or on the part of the, my lord, member to know that is there is any case pending, because, my lord, the names are similar. It is admitted with names are, there are numbers of cases, my lord, where names are
Same document is being signed in both the
Yes.
cases.
Same documents has been signed, my lord. What my submission is that same documents is signed, exhibited in these both the cases. But now your lordship will find in both the cases, though it is signed on the same date, those were not exhibited on the same date. That is one of the aspect, my lord.
You
Now-
have seen the records.
Yes,
Just,
my lord. Second,
just
my
now,
lord,
just.
and these documents were filed.
You send you the records. One of the,
Yes.
one of the documents,
Yes,
this flag. This one. Look down below.
yes,
How many cases are there under this, before the signature? Exhibit number so and so in,
case number 350, my lord.
no, 3 numbers are there. Three case numbers are given by red pen. By red pen. No, not this. The flag I showed you.
Yes. Case number 9417, 143, yes. Three numbers are there, my lord.
Yes. So if I say that the tribunal was not aware that there are 3 cases of different persons.
Yes. No, my lord, that is, I'm not saying, my lord, they may aware of this, my lord, there is another case pending against this person, against the person of this, my lord, of the same document. Because this document is exhibited in different cases, my lord.
3
There
cases.
will be 3 cases, 94, 140, 142, and 16, and 350, my lord. I don't know who are these, my lord, but there are 2 cases here before this, before us. Now also we don't know whether this, what case is this another case, my lord.
Lordship, 1432 is another brother of the petitioner. I have annexed that
Yes.
order also, your lordship,
That's
in
what, my
the
lord.
additional affidavit.
That is, who had prohibited them, my lord, while filing WS, that there are cases pending against us. They did not disclose all these things. When they are in, my lord, suddenly they are bringing into the record, well, by filing evidence.
You see,
They
unless
are
you
also-
train
they are
your, unless you train your AGP, nothing is going to happen.
That is true, my lord. That's a different aspect. But whether in evidence they have said there is a case pending, even in evidence also they
Why
have
will
not,
it say?
no, they have not
Is it
said,
relevant?
no. My lord, first of all, now, my lord, the intention is if I succeed, I will get the benefit.
So what is wrong?
If
with that?
every, my lord, their thesis is
what
that,
is
my
wrong
lord,
in
if
that?
they will not disclose, my lord, if the second one will not disclose, my sister has been declared to be foreigner. So I may be declared foreigner. They will not come with that.
You will have to go. See, you prior to this, Satyug, you'll have to go, where people will say that, yes, this is the truth. You see, adversary, this is an adversary litigation system.
No, my lord. If
The
you,
documents are
second.
done together. The tribunal should have asked, the AGP should have asked why three documents are being signed together.
That is another aspect, my lord. My lord, in this case, if your lordship may kindly see. And second aspect, my lord. Now taking,
You see, the
yes, now,
elementary question which my sister is
Yes.
there.
See, without amalgamating the cases, how he could fix a signature on three cases numbering the, after mentioning the case numbers also?
that's why, my lord, that's why, my lord, it's, I'm not, actually, I should not have said this. It could not have been done.
It could not have been done.
Yes.
The appeal should have come from you.
It could not have been done, my lord.
You, but the state is not filing an appeal.
Yes, it
But
could
you
not
are
have been
arguing as
done.
if you are arguing an appeal. It's impermissible.
It could not have
You
been.
see, from in the trial court, we both have experience. Two cases if the court will sign, then
Yes.
if we have either a common order or an analogous orders.
I don't think, my lord, there is any analogous order, there is common order. My lord, probably this document was exhibited in a case. Next day, this documents was again exhibited. My lord, I don't know whether it was placed before the tribunal or not, because
Signed it.
no,
Tribunal signed it.
they signed it, my lord, there is a sign. My lord, that's why I'm saying, my lord, your lordship also knows, my lord, I also know it well. While placing the documents, my lord, it is the court master who used to look, who used to give the exhibits and all. Then my lord, the court master, the presiding officer.
You see, I
is-
will tell you why. There
it
can be a
could-
theory, but we can't accept it. We'll tell you the reason why. Let us say that the first case, evidence was led on 1st of January.
Yes,
So on 1st of January, the tribunal will have signed the documents. But it does not sign. It is dereliction of duty. Then on 2nd, another case is placed. Same documents are exhibited. Even in the second case, the tribunal would have signed on the second day. It did not sign. It postponed its duty. It's dereliction of duty again. On the third day, 3rd of January, third case is placed.
Cool.
And the tribunal puts its signature in 3 different
can you not find?
cases in a single common exhibit. It could not have been done.
It could not have been done, my lord, that is true. Look, another aspect, my lord, suppose.
You should have taken up the issue against the is unfit to be a member, but you will not like it if I comment it from here. So I withdraw that comment as if I have not made it.
Read up. But one aspect, my lord, I'll argue on that point also. Well. My lord, this plea was not there before the tribunal. These pleas were not before the tribunal. Now they are bringing this first time by filing. It is.
No,
it
order
was
has
not-
been passed subsequently after filing this.
Yes, that's why, my lord. That's why. My lord, the order of brother is passed subsequent to this filing of this
Filing,
writ petition. So
But
now,
state is not in appeal.
no, I'm not,
So we can't remand all the matters to be taken up. That's
Yeah.
what you are coming at.
Yes,
Right.
no, I'm not challenging the brother's opinion, madam.
But you are making a statement that will come from you.
Yes, I'm not, my lord, challenging the brother's opinion. Now they are asking benefit of the order, which is passed letter to them. and which was not disclosed by them. Initially, they did not disclose. There is a case pending against their brother. Now, when the brother has been declared Indian, now they're coming before this honorable court by taking the advantage of that order. So who prohibited them? Even in the writ petition also, they did not disclose all these things, madam. Writ petition also, they did not disclose all these things. Now, when the order, positive order has been come in their favor, now they are asking for my lord benefit. Had it been disclosed in the first day itself, my lord, and later on the brother has been declared to be foreign Indian, then it's a different case. But they did not disclose that there is a case pending, even in the writ petition also. Now, subsequently, when there is order passed, they are coming with saying that my brother has been declared Indian.
We'll ask you a question. Is it so wrong so as to hold that this action of the petitioner is so bad that he does not deserve any hearing because of the impropriety done? Can we arrive at a finding because of the fact that in this first case we are having 5175, on 27 June 2025, an additional affidavit has been filed to bring on record this,
Yes.
correct? Now, when this, what is the date of the opinion?
5/11/2020, madam. Second
Five-
opinion is,
5/11/2020.
yes,
That is subsequent to filing of the writ petition.
subsequent to filing of the writ.
Now, what is, you see, therefore this, after this opinion was passed, it was brought on record by
Yes.
filing an affidavit.
Yes.
Now, please tell me how this pleading could have come in 2019 when an opinion is passed in 2020?
Yes,
No, I'm not saying, my lord, they declare so. At least they have to disclose the thing that there is a case pending against the brother, and that is also in running the, my lord, tribunal. That fact has never come before this honorable court, neither to the tribunal. Now, when he has been declared for Indian, my lord, by the tribunal, they are trying to get the benefit of that. Had it been declared to be foreigner, my lord, he would not have come with that plea. Only when he has been declared Indian, now they are taking the advantage of that. He should come with clean hand, my lord. He is not coming in clean hand.
Okay, if that is the argument, let us say that there are 3 writ petitions filed.
Yes.
Correct? In respect of, say, regularization of teachers.
Yes.
First case is dismissed, second writ petition is dismissed, third writ petition is allowed. Now, cannot the first and second people come and say that, well, the other cases have been allowed, so therefore please review? Is it so wrong?
No, I'm not that. No, my lord, that is another aspect. That is issue of, my lord, had it be issue
You
of
please
legal
tell
point,
us
my lord.
that this is suppression of material facts.
Yes,
Please, you see, no foundational facts has been, pleadings have been filed. You have not filed an objection till now. An affidavit has been filed, you have not objected to it. So your argument is wholly without any material facts. Neither it is a pleaded case, nor you have put the petitioner to notice to make that objection. You are saying that it was not disclosed. Has the state objected to it? Has the state come up and said that, well, one is declared a foreigner, and therefore the case in which the petitioner was the one person was declared to be an Indian, we are challenging that order that you have not done. So this is tacit acceptance of the first opinion, the second opinion where it was declared a foreigner, Indian. Once you admit that position, can you argue against your own, what you call, acquiescence?
my lord, I'm not arguing the second writ petition. Second.
It's an
second against the
acquiescence.
Second opinion.
That
Because
opinion.
I have no right to argue
No,
against
no, that opinion has attained finality in the front of your own eyes.
Yes, madam. That I
What
have
is-
no argument on that point because
What
I have
is-
not filed any
wha-
appeal.
wha-
matter.
Please tell us what is what according to you is the meaning of acquiescence and estoppel.
Against that, my lord, I have no right.
Then
my
you
lord.
fail everywhere. You can't object.
Yes. No, only my point was, my lord, while filing the press, they did not disclose this thing, that there is a case pending against the brother. Now, My lord, another aspect also, my lord, suppose the person, my lord, against the brother, my lord, there is a document on merit also, my lord, what I have seen. In a document against the brother, there is a, my lord, land document where the brother is appearing along with his father. But the document, the petitioner's document, my lord, against that document is, my lord, it is not there in the petitioner's case.
Which one?
In LCR, here it is, my lord, the
LCR of which case?
brother's case, my lord. If your lordship may kindly read this, these are the, my lord. Okay, we go back. Statement number is the. Okay, one.
Yes.
Request statement of association. Number eight. My lord, those are the two documents, land, but land documents,
Yes.
land Jamabandi, my lord. There, the father in the projected brother is there, my lord. Who checked it? The document, the Jamabandi.
Yes.
It doesn't mean. Salim Malik, no? Go back to. Salim Malik को declare करो. Petition. Salim Malik is there along with father. So Salim Malik has been declared Indian. My lord, in this document, my lord, both this document, the father along with the projected brother is there. So, my lord, my case is that, my lord, each and every individual's case has to be looked differently, my lord. Even though his brother or sister, whatever it may be. My lord, the Supreme Court has said it. My lord, now in this case, in the documents, my lord, the brother is along with the father. So he may be declared to be Indian because there is a document which relates the brother along with his father. Now, where is this in these documents? The sister's name is not there. My lord, petitioner's name, Amina Khatun, I guess.
It is there, your lordship, in exhibit,
No, that's why, my lord.
exhibit four,
Window marriage.
4-1 of the present case, your lordship.
My lord.
Petitioner name is there.
Yes, no, my lord, that's why, my lord. Our point is that if it is a documentary evidence, we have to accept. Otherwise, it has to prove by, my lord, or if it has to be proved by oral evidence, it has to bring some other documents by whereby it is proved. That has to be, it's a oral evidence that if there is no documentary evidence, then it has to be, it has to be treated as oral evidence. Now, later on, my lord, this is the document where it is not there. But in one of the documents, probably there is some handwritten, my lord. My lord, Lat Mondal has deposed. The statement of Lat Mondal is at page 85 and 86 in the writ petition.
Yes, your lordship.
Evidence of DW1 in your registration. Is it page
DW1,
six-
page 79. Your lordship. Sorry, your lordship, evidence of DW1 is
62?
62, 62. In paragraph 2 of last line, your lordship.
Exhibit.
Additional development talking about this. Additional. Same.
Irrespective of the penalty, how the cases been improved by the petitioner from very first day to my last till today, improving the case gradually. The first ballot appears, they filed two appears. First appear, your original is 15. When is the first appear, it is filed on ballot, is filed on ballot 8/6/2016.
750.
7/6/2008. The second appears was father. The opposite party father did.
Effect date not been mentioned, Your Lordship. As per the deposition of paternal uncle, Your Lordship, 20 to 20 years, Your Lordship.
It's WS. First WS means Here the father name is clearly mentioned with authority null. That is the only name now. There is no other Indian. And there was no disclosure that but if he has any brother or sister, any. Who are their brother is perspective. Those nothing. And they have, he has been father's name because there is father's, there was father's name. And that can be created by the right. Who was the brother? Nothing. Now. But it is the fifth, it is no, when father died, nothing is there. If this thing, out of 50, daughter of 21, according to this, her date of birth is 1960. Yes. The para 3 years critical specific, okay, was born in 1960. Yes, technically, it is her case is for 15 years.
No, her date of birth has been mentioned in
The
there.
evidence. The evidence participation are is 8 years. 2018. So it will be sometime 1958. 1958, 60, it can be another point. So now, October, it was born in 1960. But he was eligible to class 1980 before it. He became at 21 years in 1979. But there is no document of the petitioner till 1997. 1997, he has voted in 1997. Voted. It is one aspect. Now, in the second WS pilot, which is filed in 2018, this is probably pilot this has come just 2-3 days before filing of the WS pilot projected further in another case. In other case. Just 2-3 days before the filing of the WS pilot rather in that case. This was not filed from 2004. 7/6/2018 it was filed. It was filed in between July 2018. Second. Now, here he has approved the entire case. But one aspect, yes, he has said our father has aliases. Our father's name has aliases. 4 aliases: Asiruddin Ali, Asiruddin, Asiruddin Singh, Asiruddin. These aliases was not there in the earlier term. Here also, when the father died, what happened to mother? Those were not there. But brothers never happened. Brothers never happened here. And he has said the brothers have inherited the land of people. Cousin brothers will make it. This has been brought. Details of the brothers and the mother land inherited, details of land, now, it is the evidence part, the evidence part. Evidence she has again improved it. Whether this is there in the original record or not, in para 12, he has given some handwritten portion. Para 366. Traditional. Yes, handwritten part is there. In the original record, it is there or not, I don't know, my lord, but it is in the filing here. It is there. They are trying to exhibit. This was not in the original type, but later on they are trying to exhibit exhibit 4.1. Exhibit 12, but that is not, my lord, annexed here. Exhibit 4.1 is not annexed
No,
here.
no, annexed, your lordship, page 49. Page 49 of the writ petition.
4.1.
Here petitioner's name along with her brothers, your lordship, yes, my lord.
This one. Now, here it is, my lord. She has said. And later on, my name also mutated in the aforesaid land record along with my brothers on 31/7/2018. This is after filing of the WS, second of this mutation. And this is a 2018 documents, my lord. 2018, that is also after filing of the WS, not only after my lord registering the case, even after filing the WS. And in WS, she has now, this document is brought in the last moment. Well, it is project, it is settled position, my lord. What is stated in the writ petition that has to be proved in the evidence. Now, another improvement before this honorable court, my lord, by way of filing additional WS, that the brother has been declared Indian, so she should have been, she should also be declared to be. All these things, my lord, in entire evidences, WSC has filed that she has a brother. But why she has not disclosed that she has a brother which is against whom there is a case pending, and that is also running in this. Obviously, there may be a fault on the part of the Maladi of the state authority also. But is it not his duty or her duty to disclose this thing? Now, what the Gangura said, the Lat Mandal has said, and why I'm pressing all these things, in Abdul Qudsi Supreme Court has said each and every case that has to be looked separately, because one may come later, one may come prior to 1971. Here is the case where the petitioner has no documents up to 1997, who was eligible to cast vote in 1980, before 80 itself. From 1980 to 1997, there is no document at all. And now after filing of WS, she is trying to bring a document which is not studied in WS. In the evidence is this, that this piece of document has come up. In fact, that is born in after filing of the WS, and that may be taken as into evidence, and that may be taken into consideration. That is of 2018, from 1960 to 2018, there is no document. At least to 1997, and till 2018, there is no documents linking herself to either to the brother or to the projected father. In 2018, she has brought it, and that is also not disclosed prior to that. my lord, had there been an application, suppose the father died, my lord, the mutation cannot be done within 1 day. This WS was filed just, my lord, 10, 20 days, 10 days before this mutation order. There is no disclosure that I have filed a mutation application. That is also not there. And in fact, my lord, the Lat Mandal has said the mutation order is in the Sita copy, but I have not brought it in his, my lord, evidence. Cross part. PW, my lord, PW 4, my lord.
Page 85. my lord. That copy, Your Honor.
He has said, my lord, the earlier entries were done by him, but this entry was not done by him.
No, he
This-
has stated he has entered petitioner's name. Lakmandal has stated that he has entered petitioner's name in his clause. Exhibit 4 is the newly obtained certified copy of Exhibit 4 after latest correction.
In the original record, my lord, the cross part here said exhibit 4, 1 is mutated, was mutated not on purchase of land. In the original record, Hazrat Ali is written above Selim Malik and both are struck down. Serial number 4, 5, 6 and 7 are
Strike that.
struck out in the original record, but
Not so in Exhibit 2.
not so in exhibit 2. As serial number 8, the father name Keramat Ali is written as late Isab Ali in original record. The father name is written as Isab Ali in the original record. That is in the exhibit 8, serial number 8, Keramat Ali is written as father. In original records, at note number so and so, Hazrat Ali, son of late Asaruddin, is replaced by Selim Malik as by striking. In original record relating to exhibit 3, note number so and so is striken out. The last note contains some words that there is some
Then
problems in the
Yeah.
typing. May the particular. In the original record, exhibit 4, the name of Aminjan Bibi, daughter of Asaruddin, at serial number 6 is inserted by me after 17/3/2018. Yes, after 17/3/2018. The patta number so and so is new patta bifurcated from patta number 12. Exhibit 4.1 is newly obtained certified copy of exhibit 4 after
latest correction.
latest correction. The order of civil officer, circle officer are available in Sita, which is not produced today. That order is not produced, my lord. The contents, so this document was corrected on your 17/3/2018, then the correction order was not blessed.
So Lakmandal himself saying that he has inserted petitioner's name.
He said inserted the correction, the order of circle officer is not there. Now, my lord, this is the only evidence, only documents which now he can accept, he can claim, through which she can claim that she is the daughter of Switch. Now there are discrepancies in the name, madam. Discrepancies in the name. I'm ignoring the discrepancies, even ignoring the discrepancies. This document is obtained only after filing of the documents. And from 1970, we did a documents matter, at least proximity to 1970. Her date of birth is 1960, prior to 1960. There should be some document. Now, my lord, if your lordship, on the basis of that another judgment, he has been given chance to, my lord, that she is declared to be Indian. That cannot be accepted. That is not proper because Supreme Court has said, my lord, it has to be looked in a different manner, each and every case. She may have come, my lord, just prior to 1997. We cannot see. Her document, first document is of 1997. That is at the age of 40. 1997 at the age of 32, dear. 32, as per the 1997 properties. Mina Khatun, no? Now the Gawura also come. Yeah, the Gawura also come. Gawura said, I don't know whether he has come from, she has come from Bangladesh. Yes, see. Gawura has said. So he has no record. Without any record, without making inquiry, he has issued the certificate. With regard to the Gawura certificate, he has said that. Date of birth. Prior to 60, my lord.
No, 60.
Yes, more than 37. My lord, she has said 60. In her affidavit, she said in 2018, she is 58 years. So if she's 58, it should be 1958 something. So in between 1958, 60, it can be accepted, no issue, 1 and 2 years, my lord. Now, long gap from 1960 to my lord, 1997, there is no document. Now, improving the case in every stage. My submission is, my lord, that the tribunal has committed no wrong in this case. Brother's case is different. He may have come prior to what he has a valid document whereby, my lord, he could have established the link. Now, another aspect, as your lordship has pointed out, my lord, why they do not disclose, my lord, in not only in this case, other cases, so they do not like to disclose the date of my lord, father's death, when the father died. That is another issue, man. If father died in 1980, land is mutated in 2018. Just some days back, my lord, name of the brother's name have been mutated in the mother in the Jamaban. Brother's names are mutated. But why she has been left out? She has been only included when after filing of the WS. And I don't know whether there is application. Only after 10 days of filing of WS. That fact is not disclosed that I have already filed a mutation application. My name may also be mutated along with my brother's. That is also not there. Suddenly in the evidence, they will bring a document. So my submission is, in this case, the petitioner could not establish herself to be citizen of India, or either link herself to the projected father or the brother. But only one point, my lord. If they are the brothers and sisters, my lord, in the mutation order, it should have been come to. My lord, as your lordship knows it well, my lord, the mutation is made on the basis of next to kin certificates or applications. The next to kin certificate should have contained all the brothers and sisters' name. Now, after mutation of the brothers, how can her name enter? Had there been, my lord, in the next to kin, my lord, certificate, the sister's name were there, my lord. So her name should also be included in the mutated on the same day. It cannot be in the later day. This is by correction. I don't know how.
Lordship, regarding non-disclosure of the petitioner case pending against the brother, she has categorically stated in her written statement and evidence of the petitioner's brother's name, your lordship. This could have gone either way also, your lordship, against her also, your lordship. At the time of filing her written statement and evidence, your lordship, opinion of the tribunal has not come, your lordship. And after filing the written statement and evidence, your lordship, opinion of the tribunal has come, your lordship. And since her brother has been declared Indian your lordship, she has every right to produce the same before this. This. I leave it.
Mr. K. Meeranand, counsel for the petitioner, and so as for the respondents. Judgment is served.
Oblige, Your Honor.
My lord, this matter is against the ex parte order passed by the learned Foreign Tribunal 1 Nalbari. And the notice is as at page number 28. And service report, there is particular is at 36, page number 36, and translated is on at 32 page. Substituted manner. Pasted on the branch of a tree, not on the wall of the resident of the petitioner. Moreover, my father's name is Abdul Mojid, but not Fakir Ali. As per the notice, my father's name is written as Fakir Ali. Service report by Lord, yet page number 36, last part.
Yes, no. But Mr. S.C. Pandit and the petitioner also heard so and so for the respondents. Next. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the expert opinion. Which page? Expert opinion.
Service report.
No, expert opinion.
Yeah, 20 page 20 just.
Expert opinion, page 20. Dated 30 P 2022, passed by so and so. Thereby holding the petition to be an illegal migrant of post 25/3/1971 stream. Next paragraph. The petitioner has assailed the impugn order on two grounds. So firstly, on the ground that the notice was not properly served in accordance with law. And secondly, that the name of the father of the petitioner is
Abdul Mojid.
Abdul Majid, Abdul Majid, and not
Okay.
Fakir
Ali.
Ali as projected in the petition. Projected in the notice as well as in the impugn opinion. Next paragraph. The learned standing counsel for the FT matters has opposed the prayer made in this writ petition to and has made submissions in support of the impugn opinion. Next paragraph. On the perusal of the records of the tribunal, which had been called for, the court takes notice of the fact that as per the service report dated 24/10/2019, submitted by the concerned head constable within bracket border, who had been assigned the duty to serve notice, has stated in the report that the notice was pasted on a tree on a branch of a tree in a public place, and the original was returned along with the signature of the headman of the said lot, LOT. L is capital, huh? Next paragraph. In this regard, the court is inclined to make reference, is inclined to extract the provisions of order 3 5 within bracket 5 within bracket F small f of the foreigners within bracket tribunals bracket closed order, 1964. Next paragraph. From the above provision, it is the mandate. Accordingly, it is the mandate of the said provision that the process server is required to affix copy of the notice on the outer door or some other conspicuous part of the house in which the proceedee ordinarily resided or last resided. Next paragraph. Resultant the notice having not been served in accordance with law is found to have vitiated the ex parte opinion dated so and so, past in so and so. Next paragraph. Accordingly, the ex parte opinion, said ex parte opinion dated so and so, passed by so and so, is set aside. Next paragraph, the petitioner was duly represented by a learned counsel, is directed to appear before the foreigners tribunal Nalbari First, Assam, on or before 21/11/2025, and by producing a certified copy of this order. Wait for further and file a written statement of defense, and by producing a certified copy of the order. Wait for further instructions from the said learned tribunal. Next paragraph, the learned tribunal shall provide adequate time to the petitioner to prove her documents and to bring her witnesses. Next paragraph, the petitioner shall take note that no further notice of the tribunal is required for appearance as indicated above. Next paragraph, in the event the petitioner remains absent on call, it would be open to the said learned tribunal to treat the petitioner as absent on call and proceed with the matter in accordance with law. The registry shall send back the records forthwith to the concerned tribunal. Remand.
Lordship, my senior was required to place judgments. On the last occasion, my senior was required to place judgments on
Yes,
whether the statutory body is amenable to that. He was here, Lordship. Otherwise, Mr. H.K. Das was arguing this matter, Lordship, and his
we
presence.
understand that, but this has to be taken into account. You scroll for DSGI. Amen. You please scroll for DSGI. In item 12. Just wait for some time. Hello?
Item 14 of Court 1.
Your lordship, the conducting counsel was on leave, so he reached Guwahati only yesterday evening and night. So he could not read the files. A short accommodation is sought for your lordship.
You're for the petitioner.
Petitioner, your lordship.
On the prayer made by and counsel for the petitioner. Matters will adjourn today.
The date will be fixed, your lordship, on 18th of November.
At least after 2 weeks. You make a mention before the court. No, just saying 2 weeks.
Deeply obliged, your
It's a
lordship.
2024 matter.
Item 15 of Court 1. Writ Appeal 419/24.
For the respondent, your lordship, Mr. K. Gogoi is appearing on behalf of the appellants.
Why he was here?
So
Also from Mr. K. Gogoi.
before he comes, your lordship,
K. Gogoi. In item 15. Just wait for some time.
no, sir, I just want to point out one thing, your lordship. An order was passed on 21st of May for payment of area salaries with immediate effect. Now it is almost 6 months now. They have not paid yet. That
No, but
Point-
that is the issue of contention, because if you were
No,
treated
the
as,
issue is for back
if
wages, your
if
lordship.
you are treated as, what do you call, compulsory retirement,
This application was for back wages, your lordship. That was,
so we understand, but how would you calculate? Here the appeal is pending because of that only.
no, not that. Because of the back wages, it is pending, your lordship. Because of the claim of back wages, your lordship. But the area pensionary benefits, that was directed to be paid, your lordship, accepting the back wages. So that has not been paid, your lordship.
No, the part of the order which is under challenge. How would you compute your area dues?
From the date of passing of the initial order, your lordship. That has been computed, your lordship, but they are not paying, your lordship.
Sorry, I'm midst of one hearing matter going on, so lordship. Some accommodation, not any other than otherwise, lordship.
Okay, he is pressing for a prayer for
Area has not. been
area
paid.
salary. You should come at
Area
2 o'clock.
lordship, already process was.
We'll take it up at 2 o'clock. You go, when you are in a part of the matter, please go there.
Lost,
We'll take it up at 2 o'clock.
lost, I'll write. Area pension process is already
It's
going on.
okay.
But I'll just confirm whether it was given or not. Right.
Item 12.
Yes. Sorry.
Lordship, in terms of the last order, my offenders filed an affidavit. And I was to bring on record some judgments, Lordship. Judgments I do have, but I have not filed an affidavit as it
No,
is.
for filing of judgment, for submitting judgment, you don't have to file an affidavit.
That is what, so I. I do
Unless
have
there's
an-
a requirement by some, if
But-
there is a specific requirement, then I won't say anything, but
But
to place judgment,
somehow, your Lordship has gone through the order.
no, I have not. We don't have that much of time.
Last order.
We have some time, but not all the time.
uh, If your Lordship will come to page 59 of that order, last order. Below, we are of the prima facie view that an organization or a body created by a statute or under a statute would come within the purview of the definition of Article 12 of the Constitution, but would not ipso facto be treated as state for other ancillary purposes such as payment of pension, gratuity, etc. Next paragraph. Mr. Chaudhary, learned DSGI shall also bring on record judgments of the Supreme Court, so that.
To bring on record is, you have to give an advance notice to the court, because otherwise, when we read the matter, we don't have that information.
That is.
But the court doesn't say bring it by way of an affidavit.
Oh.
So you just have to give it to the advance notice of this order so that we come prepared. That's the only thing.
That is so.
Okay. Both sides are represented. Mr. RKD Chaudhary, learned DSGI, has submitted that as per his understanding of order dated 4/9/2025, or the direction in the penultimate paragraph of the order is to bring on record the case laws on which he intends to rely upon. So however, he is interpreting that the judgment should be placed by way of an affidavit.
Lordship,
Next, under the circumstances under which the order is passed, it appears to the court that the learned DSGI is to bring on record the judgment of the Supreme Court or any other court on which he intends to rely, which may not be by way of an affidavit, but sufficiently in advance so that the bench should have notice of the judgments on which reliance is placed. Next, matter stands adjourned today. List on.
I need a Lordship except. Let it be in the week commencing 17th, Lordship.
17th will not be too late.
Then, Lordship, the middle week, I'll be having some difficulty, I'll be out.
Because
Can it be on
it-
7th?
it appears that it has been substantially heard in part.
Yes, yes, yes.
Lordship, in the first week, we have got some, Mr. H.K. Das has got some difficulty in the first week, Lordship. In the first week.
Big difficulty. Put it on second week.
Second week, Lordship, I have got some fixed matter in outline like this, Lordship.
Outline bench.
10th. 10th is fine, Lordship.
Hmm?
10th is fine, Lordship.
Lord.
10th is fine.
Okay, 10, 11, 2025.
Oh, nice, Lordship.
So you addressed your problem.
Well, Lordship, normally, case laws, Lordship, case laws, Lordship, normally we submit it in the court, but then
Yeah, advance notice, it helps us. You know that. Otherwise, there would not be a reason to read the order and then morning refuse adjournment.
Lordship also. Maybe in some courts, Lordship, maybe in some courts, that's a practice, Lordship. In judgments also.
I can say. Shop to know.
Because I had the occasion of appearing in some case 6, 7 years back, when an order was passed to file the parawise comments as well. To file the parawise comments as well, so. But there was an order, so.
Evidence of. Evidence.
Where's the?
Item 3 of Code 3 for admission.
May I please, your lordship? My lord, in this case, my lord, on earlier occasion, my lord, the matter was remanded back to the concerned tribunal, my lord, just to determine that the voter list pertaining to the year 1970, where the proceeding's name, his own name was enlisted, only the discrepancy was that the village name was, my lord, wrongly reflected. Just to examine that part, my lord. Yes, my lord. My lord will kindly turn to page 77 of our High Court's order, my lord, 26/6/2023. The operative portion starts from page 78, my lord, and from para 3, page 79, my lord. Page number 77 starts onwards, my lord, Annexure 10, WBC 5238 of 2020, my lord. Now, my lord will kindly turn to page 79, my lord. From para 3 and 4, my lord, everything is very clear, my lord. Yes, my lord. Thereafter, my lord, he had approached before the concerned tribunal again, my lord, and he had produced the the corrected voter list. This is a wrong mistake which was occurred on the part of the election authority. If my lord kindly turn to page 81, my lord, the village name has been rectified and it has been rightly reflected as Kupati Mari instead of Koroti Mari. I have annexed, my lord, both the voter list of 1970. In the earlier voter list, the name of the village was wrongly reflected as Koroti Mari. And in the corrected voter list, that is at page 81, annexure 11, my lord, the name of the village has been correctly reflected as Kupati Mari, my lord. Yes, my lord. Previous voter list at page 38, my lord, vernacular. Same voter list. Page 38 of the repetition. Annexure 2. The vernacular, my lord. In the right hand side top. Yes, my lord. Exhibit B, my lord. This was exhibit B. In fact, if your lordship kindly turn to the page number 42, my lord, the name of the petitioner, my lord, is reflected. 40, I'm sorry, my lord, 40, page 40, my lord, pertaining to the year 1970. His own name is also there. And the name of the village has been wrongly reflected as Kurotimari instead of Kupotimari. I have annexed both the voter list of, rectified voter list of 1970 of the parents of the petitioner as well as the petitioner also.
No,
That later.
70, is this page 81?
Page 81 is one voter list. Which
No, in this,
rectified
what
voter-
is the village name?
Village name, my lord, in the right hand side, fourth column in the box, right hand side, page 81.
Yes, Kupati Mari.
Kupotimari, yes. Same person. From same area. Whereas if it is compared to page 38, my lord, that was wrongly reflected as Kurotimari.
Kuroti Mari.
Yes. This is the only thing, my lord, for which he has been declared to be a foreigner. And this man has his own voter list pertaining to the year 1970. I have
Where is
annexed-
that?
That is, my lord, at page 40, my lord, the wrongly reflected names of the voter list of the village, my lord. Page 40, first link. Page 40 is the vernacular. Nineteen
And,
seventy.
and the corrected one?
And the corrected one is at page 85, my lord. That is also, my lord, for the year 1970, my lord. The village name is rightly reflected as Kupoti Mari in that.
Just a moment.
Rustam Ali, he's the petitioner. Age remains same and area is also same. Same area.
1970, page 85
Yes.
and page
Page 40 is the wrong.
40.
40.
This is the wrong one.
This is the wrong one.
And another voter list of 1970 page.
Another voter
Corrected
list
one.
of parents are, the wrong one is at page 38.
Corrected one is at page.
Corrected one is at page 81 and 82.
Now what the tribunal has done now,
The tribunal has said that, my lord, just to fill up the lacuna, my lord, I have taken shelter of this corrected voter list. My lord, surprisingly, my lord, and said that he cannot change his
shows the
opinion.
finding.
Yes. My lord, it starts from page 101, my lord. 13/3/2025.
Relevant part.
Yes, 13/3/2025. And the operative portion starts from page 111. Others are the, my lord, the earlier findings in italics, my lord. The earlier finding is mentioned is in italics, my lord. Till 110 page, my lord. Right from 111, my lord, regarding the challenges which was put to challenge, my lord, the earlier impugnment.
Yes.
Yes, if I may read from page 111, my lord, serial number 3, my lord. This is a long finding, my lord.
Yes, please read.
Yes, my lord. Challenging the order dated 31/8/2020 passed by the tribunal by which the proceedee was declared to be a foreigner of post 1971 stream and illegally entered into Assam within bracket India from the specified territory that is Bangladesh on or after 25/3/71. The proceedee filed a writ petition being WBC so and so before the division bench of the Honorable Guwahati High Court and claimed that in the voter list of 1966 of village Kupotimari, PS Lahorigat in the district of Nagaon, Assam, which contains the name of A. Abbas Ali, son of Mahmud Sheikh, a serial number so and so. It was claimed by the proceedee that A. Abbas Ali is the father of the petitioner / proceedee, and that the name of A. Abbas Ali, son of Mahmud, also appears at serial number so and so.
It appears that during translation, this mistake has occurred. The Kapatimari and Karatimari, can you get an information? So, how much? Correct amount of the village. How much time would you require? 1 day. We will give you some more. Next week. It appears that it's a mistake.
Yes.
some
In
sort-
fact, my lord, the member has also admitted that the corrected voter list
It's
is
okay.
it's a corrected one, my lord.
It
It is
okay.
genuine, my
We'll
brother.
have it confirmed.
My lord.
All sides are duly represented. It appears that pursuant to order dated 26/6/2023, passed by this court in WPC 5238 of 2020, the petitioner had placed had placed before the learned Foreigners Tribunal Second, Morigaon, a copy of his parents, or father,
His parents.
his parents voter list of 1970,
And himself also.
full stop, the corrected, the current certified copy is available at page 81 of the writ petition, and the earlier version, which is in Assamese language, is available at page 38 of the writ petition.
My lord.
Full stop. The petitioner has also relied upon his own voter list of 1970 and the current certified copy in the English language is available at page 85, whereas the earlier copy of the voter list in Assamese language is available at page 40 of the writ petition. Next, perhaps in the English version of the certified copy of the electoral roll, the name of village is mentioned as Kupati, Kupati-Mari. Whereas in the Assamese version of the same voter list, electoral roll, the name of the village is referred to as Puroti, Kuratimi. Full stop. Next para. It is for the said reason that the directions contained in the order dated 26/6/2023 passed in WPC 5238 of 2020 was passed. Next para. Accordingly, the court is inclined to request Mr. A.I. Ali, Learned Standing Counsel for the Election Commission of India to have all the four voter list, four electoral roll verified with regard to the name of the concerned village. Next para, the Learned Counsel for the petitioner, Mr. Mr. Z. Ahmad, the Learned Counsel for the petitioner, shall provide a photocopy of all the four copy of all the four electoral rolls to the Learned Standing Counsel for the ECI to enable him to obtain instructions. Next para, list on
Can it be on fourth, my lord, if possible, next week?
both will be difficult.
Sixth, then.
Sixth then,
Yes, my lord.
6/11/2025. Next, before that you write, the Learned Standing Counsel for the ECI is permitted to send a downloaded copy of this order to the concerned authorities to obtain information.
Lordship. Deeply wished.
Item 5 for admission.
Lordship, on last occasion, your lordship directed to produce original document of certificate, original certificate of the petitioner. If you could only somehow you collected the same.
Oh, yes, yes, yes. Yes. Yes, yes, yes. Yes, yes. Look like.
His name appeared with his mother, lordship. His name is not recorded with his father, lordship. His father passed out after 1 month of his birth, lordship. Thereafter, his mother took shelter with her paternal house, lordship. Accordingly, under the patronage of her grandfather, birth certificate also, lordship, page 23.
But it was not written as late Muhammad Jalil Ali.
He untraced, he is not.
Late part it was whom he did lordship. If father died after 1 month of his birth.
His father is not died lordship, he is untraced, until he left the petitioner, untraced. Right.
আমাকে against দিছে নি? আমি সাক্ষী দিছে নি? নাই, কোনে কোনে?
এই সাক্ষী ডিটেক্টিভটো আহিছিল ৰাতিপুৱা আমি ডিটেক্ট কৰিছো এলাউন্স ডিটেক্ট সাক্ষীটো লোৱা নাই সি আহিছিল ডিটেক্টিভ
লোৱা নাই?
লোৱা নাই অবজেকশ্যন কৰিছে ষ্টেটে এইটো
কিয় object কৰিছে?
মেনিটেট লগাৰ বেছি ডেট লৈছে গতিকে
মা অমৃত পোৱা নাই।
আৰু ডিটেক্টিভ এজন মানুহ সাক্ষী বিভাগত আহিছে মা হ'ব পাৰে exhibited lordship yes exhibit B lordship that means hierarchy of case 55 before 45 is hierarchy is 55 of hierarchy
With seeking approval with both side lordship, my matter is still going on lordship. Otherwise, the item number in respect of 15 lordship, area pension amount lordship, and regular monthly pension for the month of October. It will be on first week of November, it will be credited to the respondent account lordship. And area amount is lordship. Lordship, yes, Senior Standing Council, Dibrugarh University lordship. And area pension lordship, area pension. Current month of October pension, monthly pension. Lordship. That is second week of November, period.
Yeah.
Plus. Apologies. Apologies.
Yes. Fine. It's fine. 8 and 9. No, we have seen, yes, rule 8 and 9, my lord, 9 is mistaken. In fact, in this judgment also, my lord. This judgment also, my lord, says settle in place of judgment. Section 9, my lord, says rule 9, no, rule 9. Rule 9, my lord, delays. In this judgment, last in 3 period, 16, 17, 18. 17, 18. Same thing.
Where is that birth certificate? Which page is the birth certificate?
Birth certificate. Birth certificate page, Lordship,
Is
page
page-
23,
It's page 23.
22.
Now, please tell us. Is the competent authority taken a decision to, the competent authorities in the Home Department, have they recommended to the Health Department to take disciplinary action against the Divisional Medical and Health Officer? He has issued a certificate.
Yes.
Can we presume that this certificate is contrary to law?
My lord, prima facie from the records that revealed, there is no, my lord, recording that it was issued after, my lord, the
Please, you see, that's not the point. We are in session of what is the issue before us?
Yes.
Is the opinion, correctness of the opinion?
Yes.
Now, are you saying that while examining this opinion, the High Court should also make an endeavor to find out as to how the birth certificate issued?
my lord,
Because for us, it is simple. We'll say that if you think this is not in accordance with law, you are the Home Department.
yes,
Lodge an FIR, get this man arrested who has issued this certificate. What prevents you from doing it?
that is,
Have you come and alleged? Is anything there before the tribunal saying that this is disputed?
that is of course not there, my lord.
It's not there. Please come to this evidence part. This is the cross examination. I'm just showing it to my esteemed sister and sending it to you. Yeah. This is the cross examination, page 87 of the LCR.
Yes. Yeah. Permit control, that is the certificate, yes, sir. Delayed registry. I don't know what it is. Yes. Issuing a who issued the certificate? Give it. That's why, whether it is noted or not, we don't know. Yet, presumption would be that. Presumption would be that if it is delayed manner, there is. No, my lord, because they have issued the certificate delayed manner. No, that's why, my lord. Yes. Yes, that. My lord, in this judgment, in the last judgment which I have pressed, my lord, here it is something written, my lord, there it is settled. It is said, the my lord, as the certificate was not along with the certificate, the report of the my lord district magistrate is not there. So it cannot be presumed, my lord. That's why I'm saying, my lord. That is a different issue, my lord. Yes. Of course. Of course, there is an issue, my lord, which can be. Definitely, it is the duty of the government to do that. Because if this kind of certificates are there, my lord, not only in this case, also, this case, there are numbers of such cases where this kind of certificates are found. Even in the lands, my lord, Jamabandi copies are found, which in fact are doubtful. That can be better. So, because my lord, the judgment which I have placed, it is said, here it is said, my lord, along with this certificate, the report of the district magistrate is not placed. So I'm not saying, my lord, it is the judgment. No, I'm not trying. Yes. Yes. No, that's why, madam, that should be in the record. Probably it may not be handed over to the person concerned, that will be in the record. What my submission is that. Yes. Whether there is order or not, we don't know, my lord. Yes.
The observation of the High Court in this order, have you read it?
Order, man.
No,
Like,
this is something you should avoid. But this is a judgment which I've read. We have put a blue mark.
Yes, ma'am.
Please read that. So this document was not tendered in evidence.
Yes,
So it was placed before the High Court for the first time.
yes.
So High Court has a discretion when exercising statutory jurisdiction. Therefore, this was examined and it was found that it does not contain, the petitioner's duty was to show that it was done, but it's not there. But this is not an authority on the point that when the evidence is tendered in the trial, before the trial court or before the foreigners tribunal, then also there is a requirement to show that.
Yes, of course, in this case, the certificate was obtained after passing of the opinion.
That's why in the High
That's right.
Court.
Yes.
But in this case, this exhibit
Yes,
is Exhibit A, filed with the,
page 23.
filed there. If you can just come to the opinion. Page 64, exhibit, this is Exhibit A.
Yes,
You see, this exhibit, the document is a private document. Now, is this birth certificate you think is a private document? Because it was not rejected on the ground that the certificate is not appended.
Yes.
So that's an issue which you are raising now. Now, can you say this document is a private document? It is for that reason that we started with this Rule 8. It's for no other reason. That is the point we are trying to ask you. You see, the law, we have shown it to you. A person registering, giving information is entitled to be provided with the extract,
yes,
correct? Now, this is the extract which is coming in evidence. Now, can you say that this extract is a private document?
that is, my lord, this observation purely, it is not a private document at all. This is a public document, my lord.
So, it go ahead. 30. Exhibit A is not a suspect. Date would be. Take this one. Takes right. It's a fine. We think, you see, please come again to page 65. This whole ground. ABCDEF. Sorry, the firstly, secondly, thirdly, and fourthly.
Yes. I'm not agreeing with this, my lord.
No, no, not that. You just hear us.
Firstly, the
Hear us
1960,
the comment.
yes,
The first, second, thirdly, and fourthly.
yes, my.
fourth is covered by the Supreme Court judgment,
Yes.
discrepancy of the age and all.
Yes.
Now, this four and this page 23, this certificate, the birth certificate,
Look,
this is an opportunity, I think the petitioner should get an opportunity to
my
put this in accordance with law.
lord, if your lordship may kindly produce this judgment. In Rupa Das, my lord, this is 2019 G5 GLT 575. Here also the certificate and certified copy of the, my lord, the extract of this, whether it is a certified copy of the extract or not. That issue is discussed. Middle part. As per this, my lord, it's not a certified copy. It's a certificate only. It's a certificate, but it is not a certified copy of the extract. That is what this.
I'll tell you why. Is an act, that's
The
registration of births and deaths. Registration of births and deaths. Okay. Yeah. Births and deaths.
नहीं birth certificate of birth. My lord, I had only one. Yes, yes, it is. Yes. Yes, ma'am. Yes, ma'am. 17, madam. Act. Source of birth and death register. Subject to any rules made in this behalf by the state government, including rules. Yes, yes. Source of birth, death register. Yes. Yes. It's registration. Yes, sir. It's registration. Yes. Subject to any rules met on the there by the state government, including rules relating to the payment of fees and postal charges, any person may cause a charge to be made by the register for any entry in the register of the birth and death. Yes. Yes, definitely. Yes, ma'am. Number B, obtain electronically or otherwise a certificate of birth or death from such register and issued in such form and manner as may be prescribed. This is my certificate to be obtained electronically. Provided that no certificate relating to any date issued to any person shall disclose the particulars regarding the cause of death or as entered in the register. Then number 2, madam. All certificates given under this section. Yes. Now it is. Yes. Yes. So ensure extracts. Yes. Right. Certificate. Both certificates given under this section shall be certified by registrar or any other officer authorized by the state government to give such certificate as provided in section 76 of the Indian Evidence Act 1872 and shall be admissible in the evidence for the purpose of providing the birth and death with the entry release. Yes. 18, madam. Section 18 of the Act 1969 provides that birth certificate which is otherwise an extract of an entry in the register of birth and death can be obtained in a manner provided under section 76 of the Evidence Act 1872 and upon obtaining such certificate by following procedure of section 76, the same shall be admissible in evidence. They are in the, my lord, in X is what? Yes, is 76. As per section, yes, extract as per section 76 of the Evidence Act. Yes. Probably, my lord, that's why letter part, my lord, still admissible in evidence for the purpose of providing burden debt. Yes. Certified copy. That is the law here, my lord, but the yes, ma'am. Yes, even we take the constitution. Yes. No, letter part it is saying, even if we take into consideration the provision of section 17 of the Act 1969, still the procedure prescribed for obtaining a certified copy under 76 would have to be followed. And only the extract which is certified by following the procedure prescribed under 76, that part would be admissible in it. It is certificate. That's certificate. Yes. Yes. Abstract. Yes. Yes. Understood, madam. But this point, in fact, madam, this is yes, 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 yes. My lord, what my submission is whether it can be accepted as a my lord, certified copy or not, certificate as per this, as per this law. Yes, my lord, that is what my lord, probably the learned the tribunal also thought that it will be a private document if it is not a certified copy. And yes, I understood, my lord. Here in this case, yes. Yeah. One more aspect, my lord. In fact, this whatever it may be, this certificate was issued in litigations, my lord, lot of litigations. Yes, yes. My lord, another issue, my lord, this certificate, of course, even though this birth certificate is accepted, my lord, this is issued only in 2017, and birth is registered in 1978. Even though we accept prima facie accept that this is there, my lord. Then also, my lord, what will be the helping now? How this will help to the petition? Because here is case, my lord, he is showing that his date of birth is 1970. Yes. Yes. No, my submission is something different. What my submission is, my lord, these are all 2017, 16 documents, my lord. These all recent documents. The person is old enough. My lord, I have gone through some other, my lord, because this issue is a complex issue, my lord, how to prove the citizenship. Other states of the, as the countries also. Britain, I have seen the Britain, my lord. They're saying when the at least earliest document of the person, even it is a private in nature also. Earliest document of at least 5 years, 10 years of his birth. Yes, that is on merit matter. That yes, my lord, I have no problem in the number 1, 2, and 3, my lord. One is firstly, my lord, 1971, 60. That is well enough. That is we can accept it. It is there. It's a wrong observation, definitely. Number 2 is also wrong. But this, with regard to this birth certificate, that is how far it can be accepted for the purpose of citizenship. Because only, my lord, 71, if your lordship is in 71 document at least. 71 is there. We have to accept it. This is a wrong observation. In firstly, the number LAC is not mentioned in the voter list of 1960. And that's a wrong observation. 60, even though it is 60 is there. 60 existed, my lord. Suppose 60 existed. And secondly, the house number is different. That can be ignored. Even it is, my lord, then exhibit E is not a certified copy of the column. Exhibit E. Not going to request exhibit E to P. Exhibit E. Those can be accepted as valid document. Documents. Let me check. now. My lord, I concede, my lord, this para 6 of the page 65. These are definitely wrong, wrong, my lord, observation. Because, and even though these are accepted, my lord, 60 voter list, 70 voter lists are there. Because partially it is of 1960 voter list. With regard to 1970 voter list, it said, my lord, the house numbers are different and the, my lord, the folio is not filled up on the top of the certificate copy, so it is not a certificate. Yeah. Yes. Yes. Yes, yes. That can be done, Madam, because this is the only document, birth certificate. Yes. Yes. Informed. Yes. Yes, ma'am. Yes. Look, one issue, my lord, my lord, it's a birth, my lord, it means a birth certificate, whatever it may be, or my lord, registration of birth, or death, my lord. It should be informed by someone. First of all, it should be informed by someone to the authority that he got birth on so and so, he died on so and so. Yes, sir. So probably in the form, my lord, that is provision. Now, if he was born in 1978, father has gone out, my lord, missing since 1978. Who informed this? Who has given this information to the birth and death register that he was born on 31/12/1978? That has to be there. Otherwise, anybody can come say he was born on this date. That is even Viratmal Singhvi also, my lord, while referring that case, referring that Mallet issue, the father or whoever give the information for registration in the school, he has to come. Or who has registered that, he has to come the evidence, to come to give an evidence that yes, this date of birth was registered by me, or this date of birth was informed by me to the authority for registration. That was the proposition in Viratmal. Yes, ma'am. No, what my understanding is, Malad, Viratmal Singhvi has said, Malad, in that case, that was in fact, that was not in, Malad, the issue here. Yes. 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 Completely expected. Yes. Yes. Yes, district magistrate. Yes. We have trained enough, my lord. We were trying to train them up, my lord, for 2, 3 occasions. Next, the comments, but my lord, in in this book itself. After 4, my lord. After 4, they refer to judgment. After the 13-4, my lord. What is there? It is, I have not done. Yes. Yes, yes, yes. That's. In that case, my lord, your lordship may remand it on to examine, re-examine everything. Dispute. Yes. In fact, this act, my lord, this act, I have come through now only. The provision of section 16(3) is included now, but earlier it was not there. 17(3). This was, yes, this was not there. Yes, in which cases, this is the certificate, okay, the certificate will be applicable. Yes. To 2023. Of course, this will be applicable only for those persons whose date of birth is after 2023. This. So this, yes. On that ground, my lord, because others are not, no issue. Only league.
Lordship, in page 61, Lordship. Page 61, section. Lord. A lot of time did to take every evidence of DW to Lordship. Lordship.
Here, we take here.
Only one, though. Only petitioner.
It adjournment which.
Adjournment.
Then he took abdominal letter. On 3 times he took abdomen. The 4th day he remained absent. So the matter was fixed for ex parte hearing.
Thereafter again, my lord, the time took time.
Proceeding as the ex parte order.
Mother lordship.
Okay.
Recall to the argument open a bit. Argument open a bit. 7 to 8 times, my lord. It was ex parte order was passed. That was recalled. Yes, that again they took time. Then 3 times. Then, my lord, ultimately on 21/06/2023, it was cross-examined. President present, the state council is present. The procedure was examined today by the state. Then matter was fixed for argument. And on the date of argument, they filed a petition that they want to introduce evidence, more evidence. Yes.
Lordship.
We may not have sufficient time for the matters. Mr. Sharma, you are sitting for which matter? Item
160.
16. In item 16, you are appearing for?
Respondents. Private respondents.
Okay, the other side is here. You are here.
Lordship, I am for the appellant's lordship.
Yes, please start. Last time you made a prayer is that there was some urgency in the matter.
Yes.
Wait. What time do you go? This will not be over in 15 minutes. We'll be rising at 3:30. 3:30 it will not be over. You're challenging the order of the Board of Revenue.
Border lordship.
Board of Revenue order is being challenged. Which is the order of the
Lordship pays
High Court order, where is that?
Lordship pays 180 Lordships. Order dated 29/8/23 Lordships. I was the writ petitioner Lordships, and my writ petitions got dismissed.
Do you have any material here, Mr. Sharma, to contradict paragraph 20 of the High Court order?
Lordships, this respondent, private respondent, he was the government servant Lordships. And Lordships, his residence is at Gandhibasti Lordships, whereas this land situated at Pamohi Lordships. And from Pamohi to Gandhibasti Lordships, it is about 30 kilometers Lordships. And also he was an employee, and Lordships, this regarding his physically handicapped Lordships. His physically handicapped, that certificate, it was issued by a senior medical officer Lordships. And Lordships, earlier one judgment was there Lordships, that is in page Lordships. Page Lordships. (153) Lordships. 153 Lordships, the judgment was delivered by Honorable Justice Asintamullah Bijarbura Lordships. And Lordships, in that judgment, Lordships, this certificate, regarding this certificate, it was clearly stated by the Honorable Court that it is unsustainable, and accordingly, Lordships, this order, it was set aside and sent back to the Additional Deputy Commissioner for fresh hearing.
Which certificate?
That is medical certificate, lordships. Medical certificate,
Where is the observation in this order?
lordships observation in this page lordships 169 lordships,
159.
169 lordships. 169 paragraph top lordships. In above view of the matter, the judgment of the learned Assam Board of Revenue dated 11/5/2007 in appeal case number so-and-so is setting aside the order of ownership in favor of occupancy tenants merely on the ground that the respondent number 1 is physically disabled person without undergoing exercising to determine the extent and intensity of the disability is unsustainable. Then lordships, bottom lordships, same page lordship, paragraph number 36. The additional deputy commissioner shall direct the respondent number 1 to subject himself to a medical board to be constituted by the state government, which would consist of at least one expert in the field of physical disability as claimed by the petitioner. On the matter being remanded back, the additional deputy commissioner shall issue
No, does it survive? Because the writ appellate court has already set aside that judgment.
lordship.
Then,
That set aside order they have annexed.
if the appellate authority has, appellate court has set it aside, it warrants no interference.
And-
Because we are not sitting in appeal over that division bench order. And secondly, the finding here is with regard to the fact that the the principles of Bikartan Das was followed. And that is why we asked you only one question. You have anything to dispute paragraph 20 of the impugned judgment?
Lordships, this circle officer has submitted a report before the additional deputy commissioner that I am in possession, lordships, and also lordships, I am the cultivator, lordships. That certificate, lordships, when that record is to be seen, lordships, record of trial court, that is case number, tenancy case number 6, tenancy case number, lordships, 66/95, in that it is clearly mentioned, lordship, this certificate.
You see, those things don't come in the way because of the fact that the tenancy case was decided ex parte without hearing the respondent number 1. And that is why it was set aside. That's why
lordships.
we are asking only one question. This section, this paragraph 20, do you have anything to contrary to show contrary to that? You are referring to, for this, you are referring to the affidavit where you have produced the photographs. That photographs were rejected. The petitioners are not personally cultivating the land. That is the finding of fact of this learned single judge. Do you have anything contrary to that?
Lordships, I have subsequently, lordship, I have submitted the documents with the photographs where I am cultivating.
That was
lordship.
rejected. That is only one photograph showing a few, what you call,
Structures.
4 people standing with the, this dao and etc.
And
Because the
also,
photographs have to be believed. Then we already have Star Wars. People coming from another galaxy attacking us.
lordship, that village, Amohi village and Deosatal, around that, lordship, those villages are the Karbi village, lordship, tribal belt village, lordship. And this land within the tribal belt, lordships. And I am the tribal man, lordships. I am the farmer, lordships. Last 65 years, since 1960, lordships, I am in possession. Earlier, prior to me, lordships, my father was in possession with the Khotian lordships. Then,
No, that's not the issue. The issue before the tribunal was, the Board of Revenue was if you are a tenant, once a tenant, always a tenant, then the case is that when it was cultivable land, you paid rent. And when it was no longer cultivable land, you did not pay rent. So the tenancy is broken. How do you prove that? We don't find anything in the record to show the existence of tenancy. Tenancy means tenancy under this act. You may be in possession, but you'll have to establish tenancy.
Lordships, my father was having the Khotian lordship. On expiry of my father lordships in 1991, I have applied for mutation lordship. And accordingly, lordships in my name, mutation was granted lordship. And subsequently, lordships, I have applied for ownership right. And ownership right lordship, and there also lordships, this notice was served lordships. Notice was served lordships, it was served to the private respondent, that is Bahar Ali lordships, and accordingly lordship this report submitted lordships before the
Just
ABC
a
lordship.
moment. You annexed these photographs. Where is that? Which page is that photograph with your affidavit? Page.
Lordship, this subsequently that one additional affidavit.
Yes, yes, there is page.
Page lordships,
Page 142 onwards is the photograph.
lordships,
Correct.
lordships.
In first page, what is the agriculture you are doing? At least we can't visualize the agriculture. And the second photograph had, what is the product? What is the agriculture?
That is Bao Pedi lordship, Bao Dhan. And now lordships, Bao Pedi lordship, Bao Dhan lordships. Now lordship, this is the season lordships, and in this season, in the month of lordships, this is not the repent stage lordships, it is just seedling lordships. Initial stage lordships. Lordships, that is also dear lordships, because this complete area is about 4 bighas lordships. 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 Outside lordships, it is Meteka lordships. Meteka lordships. It is not Than lordships, but in
It's a large field. It's a large field. In a
lordships,
large field, it is very well. Yes.
lordships, lordships, this area, this land, 4 bighas of land, it is by the side of the main road lordships. One road is going. Lordship, Lordship, by the side of the road, Lordship. Still, Lordships, this, it is a Lordship. Lordship, recent photograph, Lordship, recent photograph I can place before the Honorable Court. Recent photograph, Lordship, with road, Lordship, because there is a road, here road is not shown, Lordships. Only this field, that land is shown. Otherwise, Lordships, I can show the photograph along with the road, Lordships. That by the side of the land, road is going from Pamohi to airport, Lordships. Lordship, this notice was served, but he did not appear, and accordingly this order was passed, Lordship. Notice was served to him, Lordship, and this Jarikarok has submitted the report, Lordship. Jarikarok had submitted the report on 21/5/1995. বিচারপতি 24/5/1995 তারিখে লিখিত ঠাইত নোটিশ দিয়াত দ্বিতীয় পক্ষ নিজ হাতে নাপায় ঘৰৰ মানুহে সহি কৰি দিছে, Lordship. This জাৰিকাৰক ৰতিকান্ত বৰুৱা, Lordship. And Lordships 31/8/1995 জাননী জাৰি হৈ আহিছে ধাৰ্য 18/9/95 ইংৰাজী 19/9/95 চূড়ান্ত ৰায়. On that day, Lordships, I got the ownership right. And thereafter, Lordships, I was directed to submit the amount through treasury. Lordships, this order passed by the Deputy Commissioner, Lordships, that is sixty 69, Lordship, page 69. This is Board of Revenue, Lordship. Prior to that, Lordships. That is, Lordships, this Rayati case, Lordship, that is in Lordship, subsequently, Lordship, I have submitted an affidavit, Lordship. In that affidavit, Lordship, Lord. Lordships, twice Lordships, this ADC asked to the circle officer regarding report Lordships. Who, what is the position of the land Lordship? One time it was submitted in 1995. It is with me Lordships and it is a cultivable land. Yes.
The land in question is not fit for cultivation. And page 71. Paragraph number 5, middle portion. Page 71. Paragraph 5. Middle portion.
Lordships, this report is dear Lordship, this, when this, I have submitted the application for ownership right Lordship before the DC Lordships. At that time, DC asked the report from the circle official Lordship, and circle official Lordship clearly stated that it is a cultivable land, and I am the farmer Lordships, and I am cultivating Lordship. That report has come twice Lordship, and those report is not discussed in the Assam Board of Revenue Lordships. There is no such type of discussion Lordship. There is no such type of discussion Lordships. And last 65 years Lordships, I am in possession Lordships. Even my name Lordships, it is published in the Assam Gazette also. And also Lordships, they are residing at the Gandhivasti Lordships, whereas land is situated at Pamohi Lordships. It is a tribal belt area Lordships. Lordship, in 1969 Lordships, this Bahar Ali has purchased the land from Hussein Lordships, whereas the land is situated at tribal belt, which he cannot do. And there is a report twice Lordship. One report, it was submitted in 1995, and Lordship, subsequently Lordships, it was submitted on 18/1/2002, Lordship. And that circular visa report clearly stated that land is being cultivated and ploughed by the appellant's Lordship in 2002 Lordship. Those things Lordship. But Lordships, that as record has come, Lordships, record is with the Honorable. Lordships, accordingly, Lordship, this record was called for and Lordships, this, and accordingly, Lordship, this record. Lordship, next week, Lordship, make record next week, Lordship. Lordship, some difficulty.
जी भाई
legal men stand certain here. Okay. Great.
Item 1, WP Criminal 50/2025.
So on the last occasion, Lordship directed me to produce the record. Lordship, I've got the record and I've trademarked the relevant portions. Lordship, the original record has been submitted before the learned session judge while filing the complaint. This is the photocopy of the record. Okay. So on last occasion, I submitted some authorities. Lordship distinguish between the division bench of our High Court, where Lordship says that earlier judgment will be applicable. In support of my contention, I have submitted one judgment of Tahsildar. It is available on the record. In paragraph 35, Supreme Court says that if there are two judgments, if conflicting judgments are there, then both the judgments should be taken into consideration, and the judgment which is more expletive or explanation has been given, that should be taken into consideration. Lordship, while for High Court, Lordship, considering the constitutional judgment, probably Lordship, paragraph 30 was not taken into consideration, which clearly says that if there are two judgments and one judgment is per inquirium, then earlier judgment will be taken into consideration. But here, Lordship, Lordship, Tahsildar. Paragraph 35. Lordship, Panay City judgment, paragraph 30, probably the division bench has not taken into consideration the language stated in paragraph 30 law. That's why another division bench ruled that earlier judgment will be applicable. Lordship, for the benefit of myself, Lordship, paragraph 30 may kindly be seen. National Insurance Company versus Pranay Sethi is a constitutional bench judgment. Paragraph 30. Let's page 11. Merit. In this context, we may also refer to Sandeep Kumar Bafna versus State of Maharashtra and another reported in Sancho, which correctly lays down that the principle that discipline demanded by a precedent or a disqualification or diminution of decision of the application of per inquirium rule is of great importance, since without it, certainly a low consistency of ruling and committee of courts would become a costly casualty. A decision or judgment can be per inquirium any provision in statute, rule or regulations which was not brought to the notice of the court. The decision or judgment can also be per inquirium if it is not possible to reconcile its ratio and the previous pronounced judgments of co-equal or larger bench. There can be no scintilla of the doubt that the earlier decision of co-equal bench binds the bench of same stay. So here, Lordship, in what I have understand from if the judgment is per curiam, then Lordship earlier judgment will be taken into consideration. But in case of Sri Darshan Lordship, all the previous judgments, that is Bansal's case, Parveer Prakash, even Bihan Kumar was taken into consideration. And this is more elaborate judgment explanation is given, Lordship. And paragraph 35 of Tahsildar Lordship, it is more clear. Supreme Court says that, and in my humble opinion, there is no conflict between Bihan Kumar and Sri Darshan case. I've given a copy of both the judgment, Lordship, of the result of the law. In paragraph 20, Lordship, court is by giving detailed wise Sri Darshan. Lordship. State of Karnataka versus Sri Darshan. Lordship, all the judgments have been taken into consideration. Lordship, for paragraph 20. Paragraph 28, page 18. Lordship, paragraph 20 of Sri Darshan's case. of Sri Darshan's case. Page 18, internal page 18. Delay in furnishing ground of arrest cannot by itself constitute a valid ground for grant of bail. 20.1.1. The learned counsel for the respondent accused contended that the arrest was illegal as the ground of arrest were not furnished immediately in writing, thereby violation of Article 22(1) of the Constitution and Section 50 of CRPC, now 47 of BNSS. This submission, however, devoid of merit. 20.1.2. Article 22(1) of the Constitution mandates that no person who is arrested shall be detained in custody without being informed as soon as may be of the ground of such arrest, nor shall be denied of the right to consult and defend by the lawyer, legal or a legal practitioner of his choice. Similar Section 51 CRPC requires that every police officer or other persons arresting a person without warrant shall forthwith communicate him the full particulars of the offense for which he is arrested or other grounds for such arrest. The constitutional and statutory framework thus mandate that the arrested persons must be informed of the ground of arrest, but neither provisions prescribes a specific form or insist upon written communication in every case. Judicial precedents have clarified that the substantial compliance with the requirement is sufficient unless demonstrable prejudice is shown. Paragraph 20.14. In Bihan Kumar versus State of Haryana, it was reiterated that Article 22(1) is satisfied if the accused is made aware of the ground of arrest in substance, even if not conveyed in writing. Similarly, in Kesa Reddy Upendra Reddy versus State of Andhra Pradesh, it was observed that where arrest is made pursuant to warrant, reading out the warrant amounts to sufficient compliance. Both these post Pankaj Bansal decision clarify that written individualized ground are not not an inflexible requirement for all circumstances. Next paragraph, while Section 50 CRPC is mandatory, the consistent judicial approach has to be adopted a prejudice-oriented test when examining alleged procedure lapse. The mere absence of written ground does not ipso facto render the arrest illegal unless it results demonstrable prejudice or denial of fair opportunity to defend. Lordship, posing over submit Lordship, the petitioner is approached the once trial court and one time in the Guwahati High Court, filing bail application, seeking bail, Lordship. So it is not the case of the petitioner that he was not aware of the ground of arrest. And furthermore, Lordship, he was arrested in conscious position of the contraband, Lordship. So he was aware that why he was arrested. Yes, it is correct, Lordship, that ground of arrest was not supplied to him. Even the arrest memo and the notice under section 50 and the family member were informed. That is available on the record. My land reference also annexed with his application. Whether this is sufficient or not, I have submitted one judgment of this honorable court. While dealing with the case, Lordship has come to finding in the case of court received this judgment was of single judge. Jipula this case. Copy is forwarded to your Lordship. Paragraph 15 onward law. Paragraph 15 is Lordship has struck the notice memo of arrest and as well as notice under section 50. Then paragraph 16, married law. As per contention of charge sheet, the contraband, narcotic drugs and substitute substance were recovered from house number so and so. From the contention of the memorandum of arrest, the reason for arresting the persons have been duly disclosed. At this juncture, it would be relevant to quote the provision of section 50 CRPC as well as section 47 of BNSS so and so. Then paragraph 19. Therefore, from section 47(1) of BNSS, the requirement of law is that one arresting person without warrant, every police officer or other person arresting any person without warrant is required to communicate to him full particulars of offense for which he is arrested or other grounds for such arrest. The same also prescribed in section 50 of CRPC. Therefore, though the learned counsel for the petitioner has made a very strenuous argument to impress upon the court that non-furnishing of the ground of arrest would fatal and has supported his submission with several cases cited, but in this case, the contention of the memorandum of arrest is specific to the petitioner and gives the description of offense for which he has been arrested. And it also contains the section of law based on which the petitioner has been arrested. Thus, from the contention of the memorandum of arrest and extract herein before, the court is of the considered opinion that the said document contains the full particulars. Lordship. So this is my humble submission, Lordship. And regarding Lordship, taking consideration the Bihans Kumar's case, not the Sri Darshan. Lordship, in support of my contention, I have also placed two judgment. Lordship, that one Tahsildar's matter. And Sethi. On considering which Lordship, the division bench come to conclusion that earlier judgment will be applicable. Paragraph 30 of Sethi's case and paragraph 35 of Tahsildar's case. Lordship, 30 that yes, Lord. But in the opening paragraph of paragraph 35 of Tahsildar case, say if there is a conflict, my humble submission before your Lordship that there is no conflict to other Sri Darshan's case, that all points has been explained properly. Even if it is conflicting, then Lordship has to accept the judgment which is more explainable and where more explanation has been given. Lordship has seen in Sri Darshan's case, all points has been taken into consideration. Right from section 50 to other whether there is inclination, long inclination or Lordship case there is there. Yes, it is correct. Lordship, personalized arrest memo has ground of arrest has not been supplied. But whether Lordship the ground stated in the arrest memo as well as the notice are sufficient. And Lordship, I have submitted that in garb of habeas corpus, this application is filed for seeking bail. For garb of filing application, because in title, they said that is habeas corpus, but in petition, they said that a writ of mandamus be issued enlarging of them on bail. And furthermore, Lordship, although their twice bail application is rejected, but that has been not disclosed in their application. Yes, subsequently, my landlord may oral statement.
No, not subsequently. The very first day I have submitted, my lord. I was fair enough, my lord. I never.
But in petition, Lordship, it is not.
Yes, I agree with that.
So this is my submission, Lordship. There is no substantial repetition in any level. Not.
But only one paragraph, my lord, of a recent judgment passed on 14th October this of the Apex Court.
Lordship, he has not stated in his application, but he has submitted to his order, Lord. Yes, Lordship. Yes, yes, Lord. Yes, Lord. Yes, Lordship, first Lordship, post title. Post title, page 1. An application under Article 226 of the Constitution in India, praying for issuance of writ in the nature of habeas corpus, directing the consortium to release the petitioner who is behind the bar. Now, Lordship, prayer. Prayer, page 12. In the aforesaid premises, it is therefore prayed that your Lordship would be pleased to call for records connection with NDPS case number so and so, registered under section 21C 29 of NDPS case pending before the Honorable Court of Additional District and Session Judge, Kamrup, and after perusal of the record and after hearing the parties, your Lordship would be pleased to issue writ in the nature of mandamus, direction to release the petitioner accused on bail. Accused petitioner NDPS case and such order bail word is not me, but writ of mandamus be issued.
My lord, my lord, that judgment, my lord, only one paragraph, internal page number 6, my lord. Page number 6, my lord. Internal page number 6, my lord. Third paragraph, my lord. May I read, my lord? In state of Karnataka versus Darshan, the facts governing are quite different. It was a case dealing with the cancellation of bail, where the charge sheet has been filed and the grounds of detention were served immediately. This court has in fact given it approval to the decision of Vihan Kumar versus State of Haryana. Similarly, in Keshi Reddy versus so-and-so, this court was pleased to hold in paragraph 27 that the object underlying the provision that the grounds of arrest should be communicated has been explained by this court in Vihan Kumar versus State of Haryana and another. Therefore, the law laid down in Vihan Kumar versus State of Haryana has been approved and reiterated in the above said decision. This is the latest judgment, my lord. And my lord, one more judgment, my lord, of our court, my lord, although it's a passed by a single judgment, my lordship might have a look, my lord, only regarding Darshan and Vihan Kumar. And the rest, my lord, this the compilation, my lord, I have just written for the petitioner, my lord. Character লিখি দিস প্লিজ একটু আরবার ট্রান্সলেশন ইউজ করছ আমার এডিটর কষ্ট দিতে মাথা কেন লাস্ট They are, my lord, that annually paragraph 20, my lord, that I have not written, my lord, that's fine.
Lordship, Lordship queries, Lordship, although bail is not written here, but release is there. Then Lordship, yes. No, Lordship, here, Lordship, there are another submission. If Lordship holds that arrest is illegal, then everything will go. There is no question of bail. He will be released immediately on the basis of court order. No, Lordship, Lordship is seen, but here Lordship release the petitioner who is behind the bar since 30/10/2023. No, then Lordship, everything will go in, the entire prosecution will go.
No.
No, definitely Lordship, if is because in my humble submission, Lordship, this is my humble submission. Lordship, here his no, Lordship, here because he is challenging that his arrest was illegal. If the arrest is held to be illegal, then everything will go.
Because the constituent.
No, yes, Lordship. Then Lordship, Sri Darshan is there, paragraph 20. Because Article 22 says, yes, Lordship, Article 22 is very clear. And as well as Section 50 also clear, very clear. No, Lordship, this is my humble submission.
No.
No, Lordship.
Vihan Kumar, my lord, paragraph 33C specifically states, my lord, we clarify that the finding of this court that the arrest of the appellant stands vitiated will not affect the merit of the charge sheet and the pending case.
And Lordship, here in Darshan's case, Supreme Court says the article, even Article 22 and 20, Section 50 has been discussed and clarified that ground of arrest to be informed him. What is the purpose of Section 50? He must be aware so that he can file application for bail. So twice he has filed application for bail. Lordship. And Lordship, regarding the division bench judgment, Lordship, I submitted judgment, Lord. Regarding coordinate bench judgment, where it is said that Vihan Kumar case will be applicable, not the Sri Darshan. That's also clarified. Lordship, we take note of that. Much.
My lord, I am obliged, my lord.
Yeah. 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 NCB. Case record. Yes, is a photo. Original has been submitted before the trial court. Macho.
Single bench, item 1, review petition 21/2024.
They left my love. My love. Any date, my love. I don't have any problem. Difficult. Well,